Title 3 Bureau of Labor Relations. Article 232 Bureau of Labor Relations. The Bureau of Labor Relations and the Labor Relations divisions in the regional offices of the Department of Labor shall have original and exclusive authority to act at their own initiative or upon request of either or both parties on all inter-union and intra-union conflicts and all disputes, grievances, or problems arising from or affecting labor management relations in all workplaces, whether agricultural or non-agricultural, except those arising from the implementation or interpretation of collective bargaining agreements, which shall be the subject of grievance procedure and or voluntary arbitration. The Bureau shall have 15 working days to act on labor cases before it, subject to extension by agreement of the parties. So here in Article 232 of the Labor Code outlines yung authority and responsibilities ng Bureau of Labor Relations and the Labor Relations divisions within the regional offices of the Department of Labor. And yung mga entities ay may original and exclusive jurisdiction para i-address yung inter-union and intra-union conflicts as well as disputes, grievances, or problems affecting labor management relations in all workplaces, except din daw those related sa implementation or interpretation of collective bargaining agreements. So ang BLR ay mandated to act on labor cases within 15 working days with the possibility of extension by mutual agreement of the involved parties. Article 233 Compromise Agreements. Any compromise settlement, including those involving labor standard laws, voluntary agreed upon by the parties with the assistance of the Bureau or the regional office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commission or any court shall not assume jurisdiction over issues involved therein except in case of non-compliance thereof or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. So here, Article 233 of the Labor Code pertains to compromise agreements in labor disputes. So yung provision na ito, it aims to uphold the principle of voluntary settlement ng disputes at i-ensure na yung mga ganitong agreements ay respected and enforced unless clear evidence of wrongdoing is presented. So when we say prima facie evidence, it refers to evidence na kung saan at first impression pa lang masasabi ng sufficient para i-establish yung fact or support a conclusion unless rebutted or contradicted. Article 234 Mandatory conciliation and endorsement of cases. A. Except as provided in Title 7A, Book 5 of this Code, as amended or as may be accepted by the Secretary of Labor and Employment, all issues arising from labor and employment shall be subject to mandatory conciliation mediation. The labor arbiter or the appropriate dole agency or office that has jurisdiction over the dispute shall entertain only endorsed or referred cases by the duly authorized officer. Letter B. Any or both parties involved in the dispute may be pre-terminate the conciliation mediation proceedings and request referral or endorsement to the appropriate dole agency or office which has jurisdiction over the dispute, or if both parties so agree, refer the unresolved issues to voluntary arbitration. So here in Article 234 of the Labor Code mandates the process of conciliation mediation for all issues arising from labor and employment, with few exceptions now outlined in Title 7A, Book 5, or as determined by the Secretary of Labor and Employment. So, ibig sabihin, dito rin, yung bawat partidong involved daw in labor disputes ay kailangang mag-attempt to resolve yung mga issues sa mamamagitan ng conciliation, mediation before seeking adjudication. Article 235, Issuance of subpoenas. The Bureau shall have the power to require the appearance of any person or the production of any paper, document, or matter relevant to a labor dispute under its jurisdiction, either at the request of any interested party or its own initiative. So here in Article 235 of the Labor Code grants the Bureau of Labor Relations the authority para mag-issue ng subpoenas in labor disputes under its jurisdiction. The issuance of subpoenas can be initiated either at the request of any interested party involved in the dispute or at the Bureau of Labor Relations' own discretion. Article 236, Appointment of Bureau Personnel. The Secretary of Labor and Employment may appoint, in addition to the present personnel of the Bureau and the Industrial Relations Divisions, such number of examiners and other assistants as may be necessary to carry out the purpose of the Code. So here in Article 236, this provision allows the Secretary to address staffing needs and ensure na ang BLR and related divisions have adequate manpower para sa effectively carry out their functions sa pamamagitan ng pag-appoint ng examiners at assistants na kinakailangan. The Secretary can enhance yung capacity ng mga entities na ito para i-handle yung mga labor-related matters including mediation, conciliation, and arbitration of disputes as well as enforcement ng labor standards and regulations.
I will discuss the Article 237, which is the Registry of Unions and File of Collective Bargaining Agreements. So, ang sinasabi dito, the Bureau shall keep a registry of legitimate labor organization. The Bureau shall also maintain a file of collective bargaining agreements and other related agreements and record of settlement of labor disputes and copies of orders and decision of voluntary abbreviators or panel of voluntary arbitrators. The file shall be open and accessible to interested parties under condition prescribed by the Secretary of Labor and Employment, provided that no specific information submitted in confidence shall be disclosed unless authorized by the Secretary, or when it is at issue in any judicial litigation, or when public interest or national security so requires. So, ang Article 237 of the Labor Code, yung responsibilities ng Bureau of Labor Relations regarding the registration and maintenance of record related sa labor organization and collective bargaining agreements, which is the CBAs. So, ang Article 237 nag-aim para i-ensure yung transparency, accountability, and proper documentation of labor organizations, CBAs, and related legal proceedings, contributing to the effective regulation ng labor relations in the Philippines. So, ang BLR is tasked with maintaining a registry of legitimate labor organization na kung saan magsisilbing official record of recognized union. So, sinasabi din dito na ang BLR din ay nire-require to keep or itago yung mga files ng lahat ng collective bargaining agreements. Ganon din yung mga related agreements records of settlement of labor disputes, at mga kopya ng orders and decisions of voluntary arbitrators or panels. Yung mga repository na ito ay open at accessible to interested parties. Parang if there's some other parties na interesado na gusto niyang makita yung mga agreements, pwedeng ipakita yon ng registry of union or the CBA or the Bureau of Labor Relations para sa ganun maging transparent and maging accountability yung gagawin nila. So based din dito na sinasabi rin na ang mga employers are assess a registration fee which is not less than 1,000 pesos sa bawat CBA or with the amount determined by the Secretary of Labor and Employment para ma-support yung effective administration ng voluntary arbitration program. So ganoon din may bayad kung gusto mong makita yung mga agreements na yun. And the next one naman is yung i-discuss ko is yung Article 238 which is the prohibition on certification election. Sinasabi dito, the Bureau shall not entertain any petition for certification election or any other action which may disturb the administration of duly registered existing collective bargaining agreements affecting the parties except under Articles 253, 253A, and 256 of this code. So, sinasabi naman dito na ang Article 238 that imposes a prohibition on the Bureau of Labor Relations from entertaining petition for certification, election, or any other action that may disrupt the administration of duly registered existing collective bargaining agreements between parties. So, ang purpose ng provision na ito is to uphold yung stability at integrity of existing CBAs at para ma-prevent na rin yung mga unnecessary disruptions and labor management relations. So, ang 238, Article 238 aims para i-promote yung labor peace at encourage yung mga partido na i-honor yung negotiated agreements nila. And the last one is yung Article 239 which is the privileged communication. Information and a statement made at conciliation proceeding shall be treated as privileged communication and shall not be used as evidence in the commission. Conciliators and similar officials shall not testify in any court or body regarding any matters taken up at conciliation proceeding conducted by them. So, dito naman, ang Article 239 of the Labor Code establish the principle of privileged communication with regard to information and statement made during conciliation proceedings. This provision safeguard yung confidentiality of discussion at negotiations that occur during conciliation sessions. And it ensures that parties not involved sa labor dispute ay malayang ma-express ng kanilang concern at ma-explore din nila yung potential solution at ma-engage in productive dialogue without fear na yung kanilang statement. At pwedeng magagamit yung mga statement nila laban sa kanila in the future proceeding. This further reinforces yung confidentiality and integrity ng conciliation process kasi it prohibits conciliators and similar officials from testifying in any court or body regarding doon sa matter na diniscuss during conciliation proceeding. So, dito, ang privileged communication, masasabing makakatulong at magagamit ang Article 239 para sa privilege of communication.
Module 5, Labor and Organization. Chapter 1, Registration and Conciliation. Article 240, Requirements of Registration. Article 240 or its equivalent in the various jurisdiction often outlines the requirements for employers to register their business or establishment with the relevant labor authorities. These requirements can vary depending on the country or region, but some common elements may include like business information. Yung mga employers ay are usually required na mag-provide ng mga detailed information about their businesses, including yung mga legal structure, tulad ng example, sole proprietorship, partnership, corporation, pati na din yung mga business name, address, contact details, and nature of their operations. Next is the legal documentation. Yung mga employers, kailangan nila mag-submit ng mga legal documents na magpo-provide sa establishment and legitimacy of their businesses, tulad ng business license, permits, at iba pa. And the next is the compliance with labor standards. Registration requirements often emphasize compliance with the labor standards and regulations, including minimum wage laws, overtime pay, working conditions, health and safety standards, and other employment-related. And next, penalties for non-compliance. Alam na natin to. Yung mga hindi nagko-comply. And employees record. Tax identification number. Article 241. Chartering and creation of a local chapter. Article 241 of Philippine Constitution pertain to the chartering and creation of local chapters of political parties, organization. Ang article na ito ay nagpo-provides ng legal framework para sa establishing ng local chapter within the political structure of the country. Sa Article 241 ng Constitution ng Pilipinas, ang mga partido or organization sa politika ay pinapayagang lumikha ng lokal na mga sangay or chapters. Ang mga chapters na ito maaaring itatag sa iba't ibang lugar ng bansa, tulad ng mga lalawigan, lungsod, or munisipalidad. Sa pamamagitan ng pagkakaroon ng mga lokal ng chapters, ang mga partido or organization sa politika ay maaaring mas malapit ang mga mamamayan sa iba't ibang bahagi ng bansa. Ito ay nagbibigay ng pagkakataon para mas malapit na coordination at participation ng lokal sa bawat level. Mahalaga ang Article 241 sa pagpapalakas ng demokrasya sa Pilipinas para sa pamamagitan ng pagbibigay ng mga mechanism para sa mas malapit na ugnayan at representasyon sa pamamagitan ng mga mamamayan at mga political parties na organization. Here are some examples of how its provision can be applied. Number 1, political party A establishes a local chapter in a province. Let's say political party A wants to expand its presence and strengthen its organization in a particular province. They can utilize Article 241 to charter and create a local chapter in a province. Itong local chapter na ito ay magsaserve bilang crossroads level entry. Ano nga ba ang crossroads? Ito ay tumutukoy sa mga mamamayan, komunidad, o basihan ng lipunan na nasa pinakamababang antas ng isang organisasyon o kilusan. Sila yung mga responsible for promoting the party's platforms, recruiting members, and engaging in the local political activities. And next, ito yung youth organization B forms local chapters in different cities. Ang youth organization B aims to increase its outreach and involvement among young people in the various cities across the country. Sa pamamagitan ng Article 241 as a legal basis, the organization can establish local chapters in different urban centers. This local chapter would focus on addressing youth-related, organizing events, and mobilizing members for advocacy campaigns. And last but not the least, Advocacy Group C creates local chapters in municipalities. Advocacy Group C is dedicated to promoting environmental conservation and sustainability. Nag-decide sila na gumawa o mag-create ng local chapters in several municipalities of facilitate community-based initiatives and projects. Under Article 241, the organization can officially charter these local chapters, allowing them to work closely with residents, local governments, and other stakeholders to implement environmental programs and campaigns. This example, Article 241 enables political parties, organizations, and advocacy groups to decentralize their operation and establish grassroots level entities that can effectively engage with communities, address local concern, and mobilize support of their respective causes.
Article 242, Action and Application. Sa Article 242 of the Labor Law outlines the Bureau's processing of registration applicants. Kailangang aksyonan ito within 30 days of filing. It also mandates certification of necessary documents under oath by the Secretary or Treasurer ng organization and verification by the President kung ito ba ay authenticity and validity. Article 243, Denial of Registration Appeal. Sa Article 243 of the Labor Code, inaalaw na mag-appel ang Regional Office Denial of Registration sa loob ng 10 days, ensuring they have mechanism to challenge decisions that may hinder their operations.
Article 244, Additional Requirement for Federation or National Union, subject to Article 238 or 203 if the applicant for registration is a federation or a national union. It shall, in addition of the requirements of the preceding article. This article outlines the additional requirement that must be met by federation or national union seeking registration. These requirements are in addition to those outlined in the preceding articles of the Code. The specific requirements are not listed in the question, but they will typically include things like proof of existence, membership, and purpose, as well as compliance with other relevant laws and regulations. The first one is the proof of the affiliation of at least 10 chapters or locals, each of which must be a duly recognized collective bargaining agent in the establishment or industry in which it operates, supporting the registration of such applicants' federation or national union. This means that each of these locals or chapters must be officially recognized as a representative body that can negotiate on behalf of its members. These requirements ensure that the federation or national union has a broad base of support and representation within the industry or establishment. This is important because it ensures that the federation or national union has the authority to represent its members into negotiation and other matters. The second one is the names and addresses of the companies where the locals or chapters operate and the list of all the members in each companies involved. Ito yung mga pangalan at mga address ng mga kumpanya kung saan nag-ooperate ang mga lokal o ang mga kabanata at ang listahan ng lahat ng mga membro sa bawat kumpanya na kasangkot. Article 245, Cancellation of Registration. The certificate of registration of any illegitimate labor organization, whether national or local, may be cancelled by the Bureau after due hearing only on the grounds specified in the Article 239 of 205. This legal provision outlines the condition under which the registration of a labor organization can be cancelled. The Bureau has the authority to cancel the registration of any illegitimate labor organization, but only after conducting a due hearing. The grounds of cancellation are specified in Article 239. This means that an organization registration can be cancelled if it dispounds to be in violation of the provision outlined in the Article 239. This provision is important as it ensures that labor organizations are held accountable for their action and that they operate within the confines of the law.
Article 246. Effect of a petition for cancellation of registration. A petition for cancellation of union registration shall not suspend the proceedings for certification election, nor shall it prevent the filing of a petition for certification election. In case of cancellation, nothing herein shall restrict the right of union seeks just and equitable remedies in the appropriate court. The article states that a petition for cancellation of union registration does not suspend the proceeding for cancellation election. This provision ensures that the right and interest for the both union and its member are protected during legal process related to union registration and certification elections. This means that the process of conducting a certification election will continue as scheduled, allowing eligible employees to exercise their right to choose their representative union. Additionally, a petition for cancellation of union registration does not prevent the filing of a petition for cancellation election. This means that even if a cancellation petition is pending, eligible employees or other parties can still file a separate petition for certification election. The filing of a cancellation petition does not hinder the right to intimidate the certification election process. Article 247. The grounds for cancellation of union registration. The following may constitute grounds for cancellation of union registration. The grounds for cancellation include false statement for the adoption or ratification of constitution and by the law, or amendment the minutes of ratification, the list of members who took part in the ratification. Additionally, voluntary dissolution by the members is also considered a ground for cancellation. A. Misrepresentation, false statement, or fraud in connection with Constitution and by the law. This pertains to any intentional act of prevent false information or misleading the members during the process of adoption or ratifying these governing documents. B. Misrepresentation, false statement, or fraud in connection with election of officers. This includes any fraud activities or intentional misrepresentation of information related to the minutes of election and the list of voters during the election process. C. Voluntary dissolution by the members. This is when the members collectively decide to develop the union. It may result the cancellation of its registration.
Next is Article 248, which is the voluntary cancellation of registration. The registration of a legitimate labor organization may be cancelled by the organization itself, provided that at least 2/3 of its general membership votes in a meeting duly called for the purpose to dissolve the organization. Provided further that an application to cancel registration is thereafter submitted by the board of the organization, attested 2 by the President thereof. Sinasabi dito that an Article 248, which is allow a legitimate labor organization to cancel its registration voluntarily. Nangyayari ito at least 2/3 of its general membership votes in a meeting called specifically for the dissolution of the organization. Following the vote, the organization board must submit an application to cancel the registration, which must be at least 2 or kung sabihin natin pirmado na ng organization president. For example, Labor Union ABC facing financial difficulties in declining membership. Nagde-decide sila dito to dissolve itself voluntarily. In a special meeting convened for this purpose, then 2/3 of its member votes in favor of dissolution. Following this vote, the Board of Labor Union ABC submit an application for canceling the organization registration, signed by the organization president. Next is Article 249, which is the equity of the incumbent. All existing federations and national union which meet the qualification of a legitimate labor organization and none of the grounds for cancellation shall continue to maintain their existing affiliates regardless of the nature of the industry and the location of the affiliates. Sinasabi dito that an Article 249, which is it ensure that existing federation and national unions meeting the criteria of a legitimate labor organization and not facing the grounds for cancellation can maintain their current affiliates. This provision applies regardless of the affiliates na nag-aim to maintain the stability and continuity of the organizations and their affiliates. For example, the Federation XYZ is a national union with affiliates in various industries across different regions of the country. Despite changes in the nature of industries and the location of its affiliates, the Federation XYZ continues to maintain its existing affiliates as long as it meets the criteria of a legitimate labor organization and does not have any grounds for cancellation, it can retain to its affiliates.
Article 250, Rights and Conditions of Membership in a Labor Organization. So these are the rights and conditions. Number 1, no arbitrary or excessive initiation fees shall be required of the members of a legitimate labor organization, nor shall arbitrary, excessive, or oppressive fine and forfeiture be imposed. So, in this case, if you're applying or if you are already a member of a labor organization, so you are not allowed or they are not allowing you to pay any amount like membership fee or initiation fee. So, number 2, the members shall be entitled to full and detailed reports from their officers and representatives of all financial transactions as provided for in the Constitution and by laws of the organization. So in this case, of course, if you are already a member of the labor organization, you are entitled to have a full access, especially in the financial transactions. So that is your rights. Number 3, the members shall directly elect their officers in the local union, so as well as their national officers in the national union of federation or federation to which they or their local union is affiliated by secret ballot at intervals of 5 years. So every 5 years, it mentioned here, every 5 years, there are selecting new officers. So who are those electing the new officers? They are the members of the labor organization. So it is mentioned here as well, no qualification requirement for candidacy to any position shall be imposed other than membership in good standing in subject labor organization. So it is good that there is no qualification requirements to apply for that position like officers, but at least you're having some good experience and good knowledge in labor law, especially in the labor organization. So the secretary or any other responsible union officer shall furnish the Secretary of Labor and Employment with a list of newly elected officers. Okay. So number 4, the members shall determine by secret ballot. After due deliberation, any question, major policy affecting the entire membership of the organization, unless the nature of the organization or force majeure renders such a secret ballot impractical, in which case the board of directors of the organization may make the decision in behalf of the general membership. So if there is any issues in regards to the selecting new officers, especially some secret ballot impractical, so the board of directors of the organization, they are the one who has the right to decide. Okay, they are the one who has to do the decision. So next, no labor organization shall knowingly admit as members or continue in membership any individual who belongs to a subversive organization or who is engaged directly or indirectly in any subversive activity. So it is clearly mentioned here that if you are a member, you are not allowed that telling to anyone that you are a part of the labor organization. So it is mentioned here also that it is not allowed, you are not allowed to engage directly or indirectly activity without any permission. Of course, no? So next condition, no person who has been convicted of a crime involving moral turpitude shall be eligible for election as union officer or for appointment to any position in the union. So in these cases now, if you are a member and you are applying for that position that you are having or committed a crime, so of course you are not entitled for that position or any position. Or if they are hiring a new member for that labor organization, and of course they must there no such as crimes, so that they will hire you or appoint you in the position in the union, labor union. So next is the next condition, no officer, agent or member of a labor organization shall collect any fees, dues or other contributions in its behalf or make any disbursement of its money or funds unless he is duly authorized pursuant to its constitution and bylaws. Next is every payment of fees, dues or other contributions by a member shall be evidenced by a receipt signed by the officer or agent making the collection and entered into the record of the organization to keep and maintain for that purpose. Of course, now if there's some payment or if you are receiving any payment, there should be a receipt, and that receipt should be signed by the officer or the agent, and that receipt, it must be kept as a record. So that is very important.
Letter I. The funds of the organization shall not be applied for any purpose or object other than those expressly provided by its constitution and bylaws, while those expressly authorized by written resolution adopted by the majority of the members at a general meeting duly called for the purpose. So in this subsection of Article 250 of the Labor Code sets forth guidelines regarding sa appropriate use ng funds within labor organization. This subsection aims to promote yung responsible financial management within labor organization by ensuring na yung mga pondo ay nagagamit solely for legitimate purposes as defined by the organization's constitution and bylaws. Para na rin for transparency, yung democratic decision making, and for accountability and handling of financial resources. Letter J. Every income or revenue of the organization shall be evidenced by a record showing its source, and every expenditure of its funds shall be evidenced by a receipt from the person to whom the payment is made, which shall state the date, place, and purpose of such payment. Such record or receipt shall form part of the financial records of the organization. Any action involving the funds of the organization shall prescribe after 3 years from the date of submission of the annual financial report to the Department of Labor and Employment, or from the date the same should have been submitted as required by law, whichever comes earlier, provided that this provision shall apply only to a legitimate labor organization which has submitted the financial report requirements under this code, provided further that failure of any labor organization to comply with the periodic financial reports required by law and such rules and regulation promulgated there under 6 months after the effectivity of this act shall automatically result in the cancellation of union registration of such labor organization. So in this subsection outlines yung requirements regarding sa documentation of income and expenditures within labor organizations. So kailangan every income or revenue received by the organization daw must be documented in a record that shows its source. So importante dito yung accurate record keeping and documentation in the financial management of labor organization. This provision also establishes yung limitations for actions involving the funds of labor organizations. So here may prescriptive period within 3 years daw from either the date of submission of the annual financial report to the Department of Labor and Employment, or from the date the report should have been submitted as required by law, whichever comes earlier daw. So failure to comply with the periodic financial reporting requirements within 6 months after ng effectivity nito will result sa cancellation ng union registration. Letter K. The officers of any labor organization shall not be paid any compensation other than the salaries and expenses due to their positions as specifically provided for in its constitution and bylaws, or in a written resolution duly authorized by a majority of all the members at a general membership meeting duly called for the purpose. The minutes of the meeting and the list of participants and ballots cast shall be subject to inspection by the Secretary of Labor or his duly authorized representatives. Any irregularities in the approval of the resolutions shall be a ground for impeachment or expulsion from the organization. So in this subsection, it regulates yung compensation of officers within labor organizations. So may restriction on compensation na kung saan yung mga officers of labor organization ay prohibited from receiving any compensation maliban sa kanilang salaries. It also says here yung approval process na kung saan any compensation daw beyond what is specified in the Constitution and bylaws ay kailangan may approval ng majority ng lahat ng members. It also indicates here yung inspection and accountability. So yung minutes of the meeting where the compensation resolution is approved, as well as yung list ng participants and ballots cast are subject to inspection by the Secretary of Labor or yung kanyang representatives. L. The treasurer of any labor organization and every officer thereof who is responsible for the account of such organization or for the collection, management, disbursement, custody or control of the funds, monies, and other properties of the organizations shall render to the organization and to its members a true and correct account of all monies received and paid by him since he assumed office or since the last day on which he rendered such account, and of all bonds, securities, and other properties of the organization entrusted to his custody or under his control. The rendering of such account shall be made, number 1, at least 1 year within 30 days after the close of its fiscal year. Number 2, at such other times as may be required by a resolution of the majority of the members of the organization. And number 3, upon vacating his office. The account shall be duly audited and verified by affidavit, and a copy thereof shall be furnished by the Secretary of Labor. So in this subsection outlines yung responsibility of the treasurer and other officers responsible for the financial management of labor organizations. So may account rendering requirement na kung saan yung treasurer must provide a true and correct account ng money received and paid, as well as any bonds, securities, or other properties entrusted to their custody or control. So, kailangan din yung mga account na yun must be rendered at least once a year within 30 days after the close of the organization's fiscal year. Letter M. The books of accounts and other records of the financial activities of any labor organization shall be open to inspection by any officer or member thereof during the office hours. So in this section, it mandates that the books of accounts and other records patungkol sa financial securities of any or financial activities of any labor organization ay kailangan daw open to inspection by any officer or member ng organization during office hours. Letter N. No special assessment or other extraordinary fees may be levied upon the members of a labor organization unless authorized by a written resolution of a majority of all the members in a general membership meeting duly called for the purpose. The secretary of the organization shall record the minutes of the meeting, including the list of all members present, the votes cast, the purpose of the special assessment or fees, and the recipient of such assessment or fees. The record shall be attested by the president. So in this subsection, governs the imposition ng special assessments or extraordinary fees within labor organizations, gaya ng authorization requirements na kung saan yung special assessment or extraordinary fees cannot be levied unless authorized by a written resolution by a majority. Andyan din yung recording of minutes, which is yung secretary daw of the organization is responsible sa pag-record ng minutes of the meeting. It also says here yung attestation, kailangan yung record ng meeting ay attested ng president ng organization. Letter O. Other than for mandatory activities under the code, No special assessments, attorney's fees, negotiation fees, or any other extraordinary fees may be checked off from any amount due to an employee without an individual written or authorization duly signed by the employee. The authorization should specifically state the amount, purpose, and beneficiary of the deduction. So here, requiring individual or by requiring individual written authorization with specific details. This provision protects yung mga employees from unauthorized or arbitrary deductions and ensures na yung mga deductions are made for legitimate purposes and with the employee's explicit consent. Letter P. It shall be the duty of any labor organization and its officers to inform its members on the provision of its constitution and bylaws, collective bargaining agreement, the prevailing labor relations system, and all their rights and obligations under existing labor laws. For this purpose, registered labor organizations may assess reasonable dues to finance labor relations seminars and other labor education activities. Any violation of the above rights and conditions of membership shall be a ground for cancellation of union registration or expulsion of officers from office, whichever is appropriate. At least 30% of the members of a union or any member or members specially concerned may report such violation to the Bureau. The Bureau shall have the power to hear and decide any reported violation to meet the appropriate penalty. Criminal and civil liabilities arising from violations of above rights and conditions of membership shall continue to be under the jurisdiction of ordinary courts. So in this subsection, it outlines yung responsibilities of labor organization and their officers regarding sa education and information dissemination. So it says here, duty to inform members. This ensures na yung mga members nila are well informed about their rights and responsibilities. And it talks about then yung assessment of dues na kung saan yung mga registered labor organizations are permitted to assess reasonable dues to finance labor relations seminars and etc. It also says here yung enforcement and penalties that can result in the cancellation of union registration or expulsion of officers depending on the severity of the violation. We also see here about jurisdiction that fall under the jurisdiction of ordinary courts to ensure that yung appropriate legal remedies are available para ma-address yung mga ganitong violations.
Article 251 of the Labor Code established the right of legitimate labor organizations. So these organizations have several important rights that enable them to fulfill their roles effectively. First is a legitimate labor organization has the right to act as the representative of its member for the purpose of collective bargaining. So this means that they can negotiate with employers on behalf of their members to secure fair wages, benefits, and working conditions. Second is they are entitled to be certified as the exclusive representative of all employees within the appropriate bargaining unit for collective bargaining purposes. So this certification ensures that they have the authority to negotiate on behalf of all employees within that specific unit. The third is the labor organization can request and receive its annual audited financial statement from the employer. This information including the balance sheet and profit, loss statement, and must be provided specific timeframes. This transparency allows the organizations to monitor its finances accurately. The fourth is the labor organizations have the right to own property, whether real or personal, for the benefit of the organizational and its member. So this property can be utilized to establish resources, infrastructure, or facilities that support the needs and welfare of the members. The fifth one is a labor organization has the right to sue and be sued in its registered name. This legal standing enables the organization to protect its interests, resolve disputes, and seek justice when necessary. And lastly, labor organizations are permitted to undertake activities that are designed to benefit the organization and its members. So this activity can include initiative related to cooperative efforts, housing project, welfare programs, ganyan, and other endeavor that align with the law and support the well-being of their members. I am going to discuss the Title 6, Unfair Labor of Practices. Unfair labor practices are composed of 3 chapters. Chapter 1 is the concept. Chapter 2 is the unfair labor of employers. And the chapter 3 is the unfair labor of labor organization. Therefore, it is not only for the employers who commit unfair labor practices, but also the labor organizations. So now let's define first what is unfair labor practices. Unfair labor practices are actions or behavior by employers or labor organizations that violate the rights of workers or hinder on the working condition and relationship between employers and employees that are illegal under the National Labor Relations Act or NLRA and other labor laws. The National Labor Relations Act prohibits employers and labor organizations from taking certain action that would interfere with the balance of NLRA creates between organizations and employer. And these actions are called unfair labor practices. And now, let's proceed to Chapter 1, the concept, and the Article 258 concept of unfair labor practice and procedures for prosecution. So in this chapter, we're going to talk about the concept of the Article 258 of the Labor Code pertains to unfair labor practices and the procedures for prosecuting them. Unfair labor practices go against the constitutional right of workers or self-organization and are detrimental to the interest of both labor and management. They disrupt labor management relations, hinder the promotions of harmony, and violate civil rights. These acts are also considered criminal offenses punishable by law. The jurisdiction of civil aspects of unfair labor practice cases falls under the labor arbiters, who prioritize the resolutions such as cases within 30 calendar days. So the recovery of civil liability in administrative proceedings prevents further recovery under the Civil Code. So therefore, initiating criminal prosecution, final judgment identifying the unfair labor practice must be obtained. During the administrative proceedings, the statute of limitations for the criminal offense is considered interrupted. The final judgment in the administrative proceedings is not binding in the criminal case but serves as proof of compliance with the requirements. Now let's proceed to the chapter 2, the article 259, or the unfair labor practice of employers. Shall be unlawful for an employer to commit any of the following unlabor practices, which is the number 1, interfere with an employee's right to recognize, join, or assist a union engaged in collective bargaining or engage in protected concerted activities. Example is employers must treat union-related conversations among the employers like any other unrelated matter at work. They may not make special rules, of course, that single out the communication regarding talk about the union or place grievances for disciplinary treatment. The second is shall not join organization or shall withdraw from one which he belongs to require conditions of employment that a person or an employee dominating or providing illegal assistance or support to labor union. So, ang ibig sabihin nito is, ang mga employer ay hindi maaaring magtatag ng sarili nilang union na tinatawag na company union o maghimasok or mang-impluwensya na sa anumang union. Yon. The third one is discriminating against an employee to encourage or discourage membership in labor union, or in other words, replacing worker without strike to protect an illegal practice. The fourth is retaliating against an employee to filing a chance with or giving testimony to the National Labor Relations Act. So this means that an employee should not held accountable or punished or for seeking protection under laws when they file a complaint to provide testimony regarding violation of workers' rights. The fifth one is to refusing to encourage in good faith collective bargaining. So, ang ibig sabihin naman nito is an employer should not hinder or wag hadlangan o tanggihan ng employer ang pag-uusap tungkol sa and negotiations on necessary terms and conditions of employment with the representatives of the workers. Of course, mas maganda syempre na may maganda at matinong pag-uusap. It is important to maintain kasi the good relationship between the workers and the employers. And finally, to violate a collective bargaining agreement or making a hot cargo agreement with the union. So when we say hot cargo agreement, it is an agreement between employer and union in which employer promises to stop doing business with another employer. Next is the last chapter, the chapter T. So now we explore the article 260 or the unfair labor practice of the labor union. Labor organization. So it shall be unfair labor practice for a labor organizations, its officers, agents, or representatives. So first here is restraining or coercing employees in the free exercise of their right not to support union. So for example, by threatening employees who don't want to support union or expelling members for crossing an illegal pickup line. So the second is restraining or cowering an employee in its choice of a bargaining representatives. So by insisting on a meeting only for the particular manager or refusing to bargain the representative the employer chooses. The third one is causing or trying to cause an employer to discriminate against the employee to the purpose of encouraging or discouraging membership. So, for example, is when convincing an employer or employees who engage in anti-union activities. The fourth one is refusing to engage in good faith collective bargaining. So, for example, refusing to collective bargaining table or listen to any of the employer's proposal. The fifth is engaging in strike boycotts or other coercive action for an illegal purpose. The sixth is changing excessive or discriminating membership fees. And the seventh or the last is collecting or trying to get employer to agreement to pay for the work that it is not performed. The provision of the preceding paragraph, notwithstanding, only officers, members, or governing boards, representatives, or agents or member of the labor associations or organizations who have actually participated in organized or ratified unfair labor practices shall be held criminally liable.
The Article 252 Reportorial Requirements. This article outlines the documents that a legitimate labor organization is required to submit to the Bureau. The following are the required documents. First, its constitution and bylaws or amendments thereto, the minutes of ratification, and the list of members who took part in the ratification of the constitution and bylaws 30 days from the adoption of ratification of the constitution and bylaws or amendments thereto. Ang ibig sabihin po nito ay the labor organization must be submit constitution and bylaws including any amendments made to them na dapat din nilang ibigay yung katitikan na ratification at ang listahan ng mga membrong lumahok sa ratification ng constitution bylaws. These documents must be submitted within the 30 days from the adoption of ratification of the constitution bylaws o sa anumang mga pagbabago. The second one is the list of officers, minutes of the election of officers, and list of voters within 30 days from election. Ito po yung organization na sa paggawa ay dapat ding submit ang list of officers along with the minutes of election of officers and the list of voters. These documents need to be submitted within the 30 days of the election. The third one, it is the annual financial report 30 days after the close of every fiscal year. Ito po yung organization na paggawa na kailangan submit its annual financial report within 30 days after the close of every fiscal year. And the last one, it is the members of at least once a year or wherever required by the Bureau. Kailangan po nilang ibigay yung sa organization na manggagawa ang list ng mga membro nito at least once a year wherever requested by the Bureau. And failure to comply with the above requirement shall not be ground for cancellation of union registration but shall subject or airing officers or members to suspension, expulsion from membership or any appropriate penalty. It is important note that the failure to comply with these requirements will not result in the cancellation of the union registration. However, the officers or members to fail to comply may face disciplinary action, mass suspension, expulsion from membership, or other appropriate penalties.